Welcome back to Out of the Rough. I'm joined by my friend Richard Marcus. Richard Marcus is an attorney, and you practice family law. What kind of law do you love most to practice besides family law? You also do business law.
I do business law, I do business litigation, I do appeals, I do some criminal law. I think I like the variety more than anything else. It's tough, you know, when you're pigeonholed to one particular area, but every day is different with different clients and different challenges, legal research issues, writing, arguing in front of the Court of Appeal. It's a nice practice when it's diversified.
It's quite a bit. You're 20 years in the business, right?
Yeah.
So you're certainly a veteran. Is the economy affecting the way law is practiced?
It is. You're getting it from two areas. You're getting it on the client side, and then you're getting it with regard to the judges and the courts themselves. With respect to the clients, you know, it used to be years ago, businesses had lots of money available to spend, bringing lawsuits and then defending when there wasn't insurance. And now, not so much. People used to look at it like, hey, you've got a business expense and we just allocate money for legal fees. On the personal side of it, it's substantially different. With a lot of the family law cases that we see, a lot of the people are representing themselves. They're still living in the home together, which is
unusual?
Really unusual. And then when we go to court representing people, I'd say about 70% of the people in the family law courts are represented by themselves.
Wow.
And that's kind of new. And then on the judge side of it, the court side of it, they just don't have the resources. They're cutting courtrooms all over the place. On the civil side, they're requiring people to pay for their own court reporters, which is new. And they basically make it difficult for you to litigate your cases because people sit around waiting to be heard, and it fosters them to go out into the hallways and settle cases.
Which maybe is not a bad thing, is it?
It is and it isn't. The whole idea is, for me personally, if I can settle a case before we get to the eve of trial, I like to do it. Picking up that phone and making a phone call is really important. I have a case recently. I sent a demand letter out. The other side wrote back with another letter, and instead of starting with the letter writing campaign, I picked up the phone, called them up. We were able to settle the case, and this morning I drafted the settlement agreement. And
get to the end as quickly as possible to reduce the emotional challenges of a lawsuit, the uncertainty of it. I want to talk about something that maybe throw a little bit of curveball at you, but in real estate, there's the arbitration clause.
Okay.
Pros and cons with it. I know you've purchased real estate before.
Yeah.
Your thoughts on it as
Sure.
as the average citizen versus yourself as an attorney.
And the answer is it really depends on who you represent. If you represent the buyer, you do not want to arbitrate usually because you're going to be in a situation where you may have to sue for breach of a warranty or for some type of a defect that was hidden, and therefore you want to be able to get in front of a jury and try and get a whole bunch of damages and things. Whereas if you're the seller, you want to minimize your liability. And basically, if you have the buyer paying the money and that's it as far as you're concerned. So it all really depends upon who you represent. I know that a lot of the times they want to do mediation first in the typical real estate contract, and then if that fails, you do your arbitration, and if you don't arbitrate, you lose the right to get attorney's fees.
So let's talk about that, mediation versus arbitration.
Sure. Most of the time in my contracts, if I'm going to put in a clause for arbitration, I'm going to want to put in a mediation clause first and just do one and then the other. You can get fancy and you can have the mediator act as the arbitrator, in which case they're familiar with the case. The benefit to doing that is obviously they're familiar with the case. The downside is they're going to get a lot of information that may not be admissible in an arbitration if you apply the rules of evidence. Mediation is voluntary. The people are the ones that decide whether their matter gets settled or not by saying, okay, we agree to this resolution, and the mediator is a neutral person who tries to push them into getting their dispute settled. The benefit of mediation is you get to pick an expert in the field if you want. For me, what we do, for example, in family law cases, is if we get to that point where the attorneys can't resolve it, we go in front of a retired judge to act as a mediator, and I like to pick the judges from this place called ADR Services. Most of them are, Central District, downtown judges that we used to practice in front of before they retired. And it's usually good to get a retired judge in there that practices family law that says, if you were in my courtroom, this is how I would decide your case. And
So you get a real feel for how the information is going to come out and where the case is going.
Right. Yeah. And they'll tell you the way that it is. And then as far as arbitration goes, you basically have somebody acting in the capacity as a judge who will, if you do binding arbitration, they make the decision and you're bound by it. You agree that you're going to be bound by it, that it's going to be entered like a regular judgment, just as if you were in court, and you waive your right to appeal. Mm-hmm. And the benefit to that is, one big benefit, by the way, is you can keep it confidential. Sometimes you'll have business matters where you have financial records and you don't want that made public. Mm-hmm. Another benefit is you can get somebody also that specializes in that particular area in order to do the arbitration. If you've got a good lawyer working with you, you can have that lawyer put things in your contract regarding which rules of evidence apply, whether, for example, California law is going to apply, whether they're bound by those rules. You can make it very specific, and you can basically curtail what the powers of the arbitrator are. A lot of times people like litigation because you have the ability to do discovery, to find out information and everything else. If you do your arbitration clause the right way, you can make the same rules apply that you have under the Code of Civil Procedure in California, for example, and give a whole panoply of discovery rights to the parties.
Well, I'll tell you what, it's a lot to take in, isn't it?
Yeah.
That's why they have attorneys. They go to school for so long as you do. I want a quick shout out. Thanks for all you do in the community. I know you get involved. You're one of my fellow provisors, network group that gets together and help each other build our businesses, and I really appreciate all you do.
Oh, thank you so much.
And you have an amazing daughter.
Thank you.
Yes, an amazing family. Well, I hope you enjoyed this edition of Out of the Rough. I'm Fred Arnold. If you want to watch us online, go to scvtv.com or fredarnold.com. If you have some questions or some suggestions of great guests like Richard, email me, fred@fredarnold.com. Until we talk again, make it a great day. And I hope this information helps get you out of the rough. Bye-bye.